Hello, welcome to EPG Pathshala, the course Legal Literacy. I'm Maruk Aidenwala, a lawyer, one of your course teachers. In the next 4 modules, we are going to look at child and the law. This first module will deal with Constitution and the child. We are going to look at who is a child under law. What are the provisions under the Constitution relating to a child? And we are also going to look at the Right of Children to Free and Compulsory Education Act 2009. Who is a child? The Oxford Dictionary describes child as being a young human not of full physical development. Hence, a child in layman's term is a person who is not fully physically or mentally developed. He is physically and mentally immature. The Constitution of India does not define child, but we have several legislation in India relating to children. In legislation, a child is related to his age. The different legislations in India have a different description of the term child depending upon the objective of the act. At the international platform, the Convention on the Rights of the Child, which India has acceded to on 11 December 1992, fixes the age of the child at 18 years. Article 1 of the Convention on the Rights of the Child. For the purpose of the present convention, a child means every human being below the age of 18 years, unless under the law applicable to the child, majority is attained earlier. The Indian Majority Act 1875 states that the person attains majority on completion of 18 years. Hence, the age of majority in India and the age of child mentioned under Article 1 of the Convention on the Rights of the Child is the same. Now let us look at certain other legislations and how they define the term child. The Indian Contract Act 1876. Every person is competent to contract who is of the age of majority according to the law to which he is subject. What is a contract? A contract is an agreement between two parties which is binding. A child due to his mental immaturity is not able to bind himself, as he may not know the implications or consequences of what he is doing. Now let us look at the provisions under the Indian Penal Code. Section 375 defines rape. It also states that 18 years is the age of consent for sexual activity. The age of consent for sexual activity is also known as the statutory age for sexual activity. This increase of this age from 16 to 18 is being widely debated because by this increase, what was once an acceptable behavior is now being penalized. Subsection 2 of Section 376, Clause I, states that if the victim is less than 16 years of age, the offence would be treated as an aggravated offence. An aggravated offence is an offence which the law treats more severely. Section 82 of the Indian Penal Code. It states that the act of a child under 7 years of age is not an offence. What does that mean? That means that if a child under the age of 7 years commits an offence, he will not be prosecuted, nor will he form part of the juvenile justice system because he does not understand that what he has done is wrong or does not know the consequences of the act. Section 82 deals with the minimum age of criminal responsibility. Every country has to lay down a minimum age of criminal responsibility. 7 years is too low an age. Hence, child rights activists are campaigning that it should be increased. Section 83 deals with an offence committed by a child above 7 years and under 12 years who is of immature understanding. It states that nothing is an offence which is done by a child above 7 years of age and under 12 who has not attained sufficient maturity of understanding to judge the nature and consequences of his conduct on that occasion. Who is going to judge whether the child is of sufficient maturity of understanding? It will be the Juvenile Justice Board who will have to answer this question, maybe with the help of child psychologists or counselors. The Juvenile Justice Care and Protection of Children Act 2015. Child means a person who has not completed 18 years of age. This act deals with two categories of children. 1. Child in conflict with law. 2. Child in need of care and protection. The Protection of Children from Sexual Offences Act 2012 is a special law dealing with sexual offences committed against children. We will be looking at this law in detail in a later module. Under this act, child means a person below the age of 18 years. The offence is more severe if the child is below 12 years of age. The Child and Adolescent Labour Prohibition and Regulation Act 1986. It has been amended in 2016, and now this act deals with two categories. 1. Child means a person who has not completed 14 years of age, and adolescence. That is a person who has completed 14 years of age but has not completed his 18th year. The Immoral Traffic Prevention Act 1956 has three age-wise categories. Child, a person who has not completed 16 years of age. Minor, who has completed 16 but not 18 years of age. And a major is a person who has completed 18th year of age. With regards to child-related legislations, they deal with children between 0 to 18 years of age. Though a child is a person who has not completed 18 years of age, within this range they may be treated differently depending upon the objective of that act. Now we are going to look at certain child-related provisions contained in the Constitution. We have looked at the Constitution earlier in Module 1 to Module 6. So, some of these slides may be a repetition. As you are aware, Article 50 is a fundamental right dealing with non-discrimination under certain grounds. Under Clause 3, the state is allowed to enact legislation, special legislation for children, recognizing that children require special protection and special entitlements. The state has enacted several laws for children. Article 21A, which was inserted in 2002 by the 86th Amendment. It deals with right to education. It states that the state shall provide free and compulsory education to all children of the age of 6 to 14 years in such manner as the state may by law determine. This law has been enacted, which is the Right of Children to Free and Compulsory Education Act 2009, which we will be examining later in the module. It is important to note that though the Article 21A was inserted in 2002, the Act was enacted 7 years later. Article 23 deals with prohibition of traffic in human beings and forced labor. We have looked at this provision in great detail in an earlier module. We have also looked at Section 370 of the Indian Penal Code, which deals with trafficking of persons, and the Immoral Traffic Prevention Act we shall be looking in a later module. Article 24 deals with child labor. Prohibition of employment of children in factories, etc. No child below the age of 14 years shall be employed to work in any factory or mine or engaged in any other hazardous employment. What is hazardous employment? That was dealt with under the Child Labour Prohibition and Regulation Act 1986. It contained a schedule which listed the occupation and processes which were hazardous and in which a child under 14 years could not work. The Child Labour and Prohibition Regulation Act has been amended in 2016 and its title has now been changed to the Child and Adolescent Labour Prohibition and Regulation Act 1986. As the title indicates, now this law deals with both children and adolescents. Under this act, a child is a person who has not completed 18 years of age, and such child should not be working in any occupation or process, whether hazardous or non-hazardous. Such child should be in school. An adolescent is prohibited from working in hazardous occupations which are listed under this act, and their working in non-hazardous occupation is regulated. Article 29, Clause 2 deals with regular educational institutions, and we have examined it in an earlier module. Article 30, Clause 1 deals with minority and minority educational institution, and this also has been dealt with in an earlier module. Article 39 is a directive principle. It has certain provisions which directly relate to a child. That is Clause E and Clause F. Let us first look at Clause E. Please read it carefully. Clause E states that a child of tender age should not be put to work. It also states that merely because of economic necessity, a person should not be put to work in a vocation which is unsuitable to their health and strength. Hence, very young children should not be in work, they should be in schools. Clause F, that children are given opportunities and facilities to develop in a healthy manner and in conditions of freedom and dignity, and that childhood and youth are protected against exploitation and against moral and material abandonment. The state should create opportunities and facilities to enable a child to develop in a healthy manner. Several legislations have been enacted by the state to bring into effect the spirit of Clause F. Two of these legislations are named in this slide, and we will look at them in detail later. Article 44, which deals with the Uniform Civil Code for the citizens. Please read it. Family laws and personal laws contain several provisions which directly relate to children, such as adoption, custody, maintenance, succession. But under Article 44, the state is requested to come up with a uniform civil code so that all children in our country are treated in the same manner. But as we will be seeing, the Supreme Court has said that it is for the state to decide, depending upon the correct time, to come up with a uniform civil code. Article 45, provision for early childhood care and education to children below the age of 6 years. Article 45 has been reworded with the insertion of Article 21A by the 86th Constitutional Amendment in 2002. Now it deals with early childhood care and pre-primary education. Fundamental duties. Article 51A. Clause K has been inserted by the 86th Constitutional Amendment in 2006, It also deals with the right to education. It casts a duty upon parents and guardians to put their children and ward between 6 to 14 years in school. In Mohini Jain versus State of Karnataka, it's a 1992 judgment of the Supreme Court. It has recognized right to education to fall within the ambit of right to life. The Unni Krishnan judgment, also of the Supreme Court, passed soon thereafter in 1993, also states that right to life covers right to education. Now we are going to look at the Right of Children to Free and Compulsory Education Act 2009. We have attempted to summarize this act in simple language. Preamble. The objective of the Act is an act to provide for free and compulsory education to all children of the age to 6 to 14 years. The preamble is in conformity with Article 21A of the Constitution. Let us look at certain definitions. Section 2 lays down definitions. We are going to look at certain important ones. Subsection C. Child means a male or female child of the age of 6 to 14 years. Section D defines a child belonging to a disadvantaged group. Means a child belonging to the scheduled caste, scheduled tribe, the socially and educationally backward class, or such other group having disadvantage owing to social, cultural, economic, geographical, linguistic, gender, or such other factor as may be specified by the appropriate government by notification. Now let us look at Clause E. Clause E defines a child belonging to weaker section. Means a child belonging to such parent or guardian whose annual income is lower than the minimum limit specified by the appropriate government by notification. A child falling under Clause D and Clause E should be provided with facilities and opportunities to attain education. To ensure this objective, this Act reserves seats for children belonging to this group. Section 2, subsection F defines elementary education. Means the education from 1st class to 8th class. Section 2, subsection N is extremely important because it defines the term school. It has separated schools into 4 categories. 1. A school established, owned or controlled by the appropriate government or the local authority. This is a state-run school. 2. An aided school receiving aid or grants to meet whole or part of its expenses from the appropriate government or the local authority. This is an aided school, whether partly aided or wholly aided. 3. A school belonging to a specific categories. 4. An unaided school not receiving any kind of aid or grants to meet its expenses from the appropriate government or the local authority. Clause 4 deals with private unaided schools. It is important to note that all these categories of schools should be recognized and they should be imparting elementary education. Section 3 deals with the right of a child to free and compulsory education. 1. Every child of the age of 6 to 14 years shall have a right to free and compulsory education in a neighborhood school till completion of elementary education. The importance is on the phrase till completion of elementary education. Hence, if a child has crossed the age of 14, still he should be provided with free education till he completes elementary education. 2. No child shall be liable to pay any kind of fee or charges or expenses which may prevent him or her from pursuing and completing elementary education. Section 4. A child above 6 years who has not been admitted to school shall be admitted in a class appropriate to his or her age. If enrollment of a child in school has happened at a later age, he should be put in a class appropriate to his age. This is to ensure that a child is not humiliated. A child may be very uncomfortable if he is in class with children much younger to him. But to ensure that the child is on par with the rest of the students, he should be provided with special training. And as I've earlier said, it is not the age of 14 which is important. The importance is that he should be able to complete elementary education, because it is only on completion of elementary education is a child able to enter vocational training. School's responsibility for free and compulsory education. School under section 2N1. If you will recall, that is a state-run school. In a state-run school, free and compulsory elementary education should be imparted to all children enrolled therein. 2 deals with schools under section 2N clause 2. If you will recall, these are aided schools, by either wholly or partly aided. In such schools, free and compulsory elementary education to such proportion of children for which it receives aid, subject to minimum of 25%. School under section 2N clause 3. This refers to special categories of schools. Admit to class 1 at least 25% of children belonging to weaker section and disadvantaged group in the neighborhood, and provide free and compulsory elementary education till its completion. For children belonging to the disadvantaged group and the weaker section. What do we mean by children in the neighborhood? Rule 6 of the right of children to free and compulsory education rules defines neighborhood. Neighborhood is defined in the context of distance of the school from the residence of the child. For example, it states that if a child is in the 1st to 5th standard, then a neighborhood school is a walking distance of 1 kilometer. The school under section 2N clause 4 are the unaided private schools. They too are required to reserve 25% of the seats in the 1st standard for the disadvantaged group or children belonging to the weaker section from their neighborhood. The expenses incurred regarding such children will be reimbursed by the state. Certain duties which a school is to perform. No collection of capitation fees at the time of admission. Very often we hear that to admit a child into school, capitation fees are asked. 2. No screening procedure for child and parents or guardian at admission. Every child should be enrolled in school. 3. No child should be denied admission due to lack of date of birth proof. 4. No child shall be held back in any class or expelled from school till completion of elementary education. The focus is on completion of elementary education. A child should not be denied admission merely because such child has no proof of date of birth. The parents could be asked to make an affidavit stating when the child was born. No child shall be subjected to physical punishment or mental harassment. Corporal punishment is prohibited. No school shall be established or function without certificate of recognition. Every school should be recognized. If they are not recognized, they cannot function as a school. 7. To maintain the norms and standards as specified in Schedule to the Act. For example, the schedule speaks of the teachers-pupil ratio. It is very important to ensure that all children enjoy the fundamental rights and directive principles that have been framed in their favor. It is not as if it is only these provisions which deal with children. Children are human beings, and all the provisions which deal with human beings in the Constitution will also, of course, apply to children. As social workers, it is important for us to know the child-related provisions in the Constitution and the legislature to ensure that children enjoy their rights. Thank you.